Hey, good morning, guys. How you guys doing? All right, so first and foremost, we just want to thank you guys for coming out and taking time out of your busy schedule to spend a weekend with us. Catherine and I are, as you guys know, the co-chairs of the 37th annual Froessel Intramural Competition. And basically today we're going to be talking about the brief writing process. And so I'm going to let Catherine sort of introduce this, or tell you guys about the speakers who are going to be talking to you guys today, and then we're going to have the speakers come up and they're going to talk to you a little bit about the organization. Professor Abraham is our faculty advisor. She's going to be the first person speaking to you, and she's going to talk to you a little bit about Froessel and her role as our faculty advisor, and then we're going to have Mike and Garrett, who are the executive editors of the organization, talk to you about the brief writing process, timing, editing, citations, so on and so forth. So here you are, Catherine.
Hi, guys. Thank you again for coming out today. We were hoping for rain. I know it's not easy to be here in the sun, but I promise you that we'll make this as painless as possible. We have our executive editors here. As Ariel said, they are the experts in Moot Court on editing, brief writing, and citations, and blue booking, and everything that you guys really need to become experts in order to get on to Moot Court and also to do very well in competitions when you're on Moot Court. So what we're going to do is first have our faculty advisor, Professor Abraham, come up and speak a little bit about Moot Court as an organization and what our role is. And then we will get to the executive editors to talk about kind of what you guys should expect, what the expectations are for the brief writing portion of Froessel.
Hi, everybody. Professor Abraham. I'm the faculty advisor for the Moot Court Association, and I'm the least important person here today because Moot Court is totally student-run. The students do everything, and that's one of the best things about Moot Court is that it's a place in law school where you're actually treated as an adult. You're a professional. It's all about doing what you do because you want to do it, you want to learn, you want to take charge, you want to be a better brief writer, a better oral advocate, and everybody kind of works as a team on Moot Court to help each other achieve those goals. My role is to help give advice, to give support. I also really enjoy mooting, doing practice moots of students on Moot Court before they go to competitions away, and all of the faculty at New York Law School share in that role. So if you end up being on the Moot Court Association, one of the really cool things about it is that you teach yourself a whole new area of law when you go to a competition. You write a brief, you totally dive into it, learn everything you can about that area of law. You learn how to write a brief, you work with each other on doing it, you get feedback from fellow students, and then when it's time to practice oral argument, you get experts in that field from our faculty, from our alums, who really enjoy coming in and mooting you in addition to the students mooting each other, so that not only do you learn everything about an area of law and sometimes become more expert than even faculty in the area if it's on an issue of law that's kind of narrow that they don't know as well as you do. But you also become really great oral advocates and brief writers. Those are things that will help you no matter what you do, whether you want to do appellate advocacy, which is kind of what Moot Court is, appellate advocacy, or if you want to be a trial lawyer, or if you don't want to do any of those things, but you need to be able to stand up and make a presentation and think on your feet and respond to tough questions and be creative and be articulate and look like a natural up there. I mean, half of the people on Moot Court started out feeling really uncomfortable about speaking in public, and now all of them can do it really, really well. And as a side benefit, it's something that really looks great on your resume because employers really know that if you've gone through Moot Court competitions, then you're somebody who can just kind of hit the ground running, teach yourself how to do things, take charge. Because people in Moot Court not only learn how to be great oral advocates, how to be great brief writers, how to be really strong collaborators because everyone has to work together on a team, but really also leadership skills. You interact with faculty, you interact with the administration, you learn how to run an organization, you learn how to step up and just sort of do whatever needs to be done. So I'm really in the background most of the time. I'm here for when people need me. The students are totally creating Froessel. We have 2 student authors who are deviously hiding somewhere now, creating the tough fact pattern that you will have to be writing your brief about, but it's going to be really great, really exciting. It goes through drafts and drafts and drafts, and we have our 2 editors here who are going to make it really, really perfect, and I think you're going to really enjoy it. We always have a really fun fact pattern in Froessel, but the students do it all, and then students grade the briefs, and then students organize the competition in the fall and September, where we have outside judges, faculty, and some moot court members sitting to judge the oral arguments. So if you have questions, really reach out to the students, to Ariel and Catherine, who are the Froessel co-chairs, and make sure you ask them. Every year I'm surprised to see that students who have worked really hard on the brief and actually turned in the brief, hung in there all through the summer and written it, then drop out before the oral argument happens because they can't take the amount of work or something like that. If you have that fleeting thought, don't do it. The oral argument's so much fun that if you've put in the work and you've done the brief, whatever happens at the oral argument is just fun. It's extra. It's a great learning experience. Whether you make the team or you don't, you have this experience of having gone through these rounds of oral arguments, getting feedback, and it's really great. If you make the team, even better. So hang in there. I'm really impressed to see you guys here on a beautiful summer day. And we have a lot of Moot Court members here to kind of give you the answers, cheer you on, and guide you. We have our chair and vice chair of Moot Court here, Mark O'Neill and Catherine Baxter, Kate, sitting here just because they want to be here, because Moot Court members kind of love Moot Court and have a lot of energy and enthusiasm, and that's why they're doing this. So I'm happy to talk to you after it's over, but the students are really running the show. So good luck and hang in there. That's my advice.
Thank you, Professor Abraham. All right, so with that being said, we're going to turn over the microphone to Mike and Garrett, who, as I said before, are our executive editors, and they are essentially going to walk you through the process. This is their show today. Please try to pay attention because the brief writing process is an important part of the Froessel competition. All right, guys, so.
We will also talk to you a little bit about, there will be rules posted on the Froessel website sometime later on this week, and it'll talk about sort of what the proportions are of what your oral argument score is and what your brief score is, and it sort of changes throughout the competition. So as Ariel said, the brief writing portion is very important, and not so much just for moot court, but in practice. A lot of judges will admit that sometimes you win an argument on paper. So, really try and pay attention. This is something that will be great for your careers as well. And if you have any questions, we'll open up the floor later on for any Q&A. So, thank you guys.
Good afternoon, guys. My name is Mike Rasciuto. This is Garrett Baldwin.
Hi, everyone.
We're the executive editors of Moot Court. And we're going to talk to you a little bit about writing a brief, what a good brief consists of, what we're going to be looking for when we're grading the briefs. It's really important to write a good brief in the Moot Court competition in Froessel because early on, 50% of the score comes from writing the brief. As you move on, it goes to 60-40, 70-30, but the brief remains a part of your score up until the final round. Then it becomes the oral argument. So you really need to get a good base. You need to write a good brief in order to advance and ultimately make the team.
Yeah, it can mean the difference between moving on from a round, and it cannot be overstated that the attention to detail in writing a brief is one of the most important things you can do. Not just because it helps with organizing your thoughts, but also when it comes time to do your oral argument, you'll be able to sit there and go through your brief and take the points out that you've already done, and then it'll help you structure any sort of argument you plan to make. So we're here to help you figure out how best to do this.
And hopefully we cover all the bases. We did, there is a packet up here if you haven't grabbed one already. It will be available online as well for anybody that you know that couldn't make it today. It goes through a lot of material that we just can't cover in a 1 hour lecture. It is pretty comprehensive. If you have any questions about this, feel free to reach out to us either after today or reach out to Catherine and Ariel, and they can provide you with whatever answer you're looking for. And we'll also be available for questions after.
So, to start, we had put together in the packet a bit of a scheduling for the rest of the summer. As you might be, I don't know if you're aware of this, but the fact pattern is going to be released on July 14th. That's a Sunday, right?
Yep.
And starting from that point onward, we have a list of suggestions as to how to go about planning the brief writing process with you and your partner.
It's labeled as page 2, but I think it's actually page 3 here. Following this schedule is actually really important. My partner and I followed it pretty much to the T last year, and these are the dates that you do need to make in order to get a brief done. There was a lot of people hanging out, upstairs on the 5th floor last year, the day before, the day the brief was due, and they were not even halfway done with it, and it's like, you don't want to be there. If you follow this, I guarantee you that you will have a much better brief than if you just decide to, wait till last minute.
And the people grading this, people on the Moot Court Association, will notice that. It's very clear when somebody spent a lot of time in doing some thoughtful legal analysis and writing a good brief versus somebody who put it together at the last minute. And I mean, in the end, points matter. And there are deductions for all sorts of errors can come out of your brief. And then, at the end of the day, in Froessel or in any other Moot Court competition, that affects how far you go. So, it's important to really stick to a schedule and get things done.
So before you start writing, you should definitely read the competition rules. As Catherine said, they're going to be coming out within a week. The rules from last year's competition are up on the website now. You can look them over, but I wouldn't recommend it because the rules are going to change slightly. So when they do get released, you'll get an email just letting you know that they're up there. And you should definitely read through them. That way, when you get the fact pattern, you know what the rules are, you know what you have to do. All you have to do is start researching and get acquainted with the facts that you're going to be working with.
And to that end, the facts are the key part of this whole thing. I mean, you're going to need to know inside out what the fact pattern is all about. And it's going to be a rather lengthy fact pattern, not something that you may have encountered before, of a lot of detail. And it's important to do an outline even of what's going on in the case to figure out what you need to do and what sort of research you need to do. As you see up here, Froessel is an open universe competition, so there'll be cases that the authors have used in the fact pattern, but doesn't mean that you're not allowed to go out there and find other cases to support your argument. So being intimately familiar with the facts here will help you go out there and make distinctions between cases that you find.
Yeah, you're expected to go outside of the cases cited in the fact pattern itself. There's going to be a lot of Supreme Court decisions, but keep in mind that circuit court decisions and district court decisions can be persuasive as well. Not as much as prior Supreme Court decisions, obviously, because you're arguing an appeal to the Supreme Court, but they are important, and we do expect you to do some outside research and cite to things that are not in the fact pattern. To that end, you can also go and, if you find any interesting articles, really anything.
Any sources that are credible and you can use it to support your position.
Feel free to cite it. I wouldn't go crazy citing too many secondary sources, law review articles, but one or two here or there, if they're really on point, will make your brief better. So scheduling, the brief will be released on the 14th. They're due by 9 p.m. on the 11th. The rules will state there needs to be an electronic copy submitted by 9 p.m. We also need 4 paper copies submitted into the Moot Court office by 9 p.m. You can mail them if you're not going to be around on that date to get them in, and they need to be postmarked by 9 p.m. on August 11th. So I believe the 11th is a Sunday, so you would have to get them to the post office on Saturday. Can't stress enough to you how important it is that you get the brief in. Failure to submit the brief would disqualify you from the competition.
And just as a general matter, I mean, when you're in practice, you're going to have to meet deadlines with courts, and if you're doing moot court competitions, you'll have to submit it to the competition school. So, deadlines are very important, not just for us, but for anything else you might be doing. So we kind of look through that. Right. So one thing that I know proved helpful for me, and I know for others, is creating a chart of the cases that are cited in the fact pattern. Doing so will help you orient yourself to what the law is, and also just for general purposes, when you start to write your brief, you'll have all the citation there, the court, what the holding was, any sort of relevant concurring or dissenting opinions, and just to get an idea of where the law stands on the issues that you're doing here.
Yeah, usually what I like to do is I make a separate Word document and I just copy and paste some important language with the cite from Westlaw. And that way I have it when I'm writing the brief, I'm like, oh, I remember this quote, I can just turn to that document and get the language that I want. We stress that you should try to paraphrase when possible. The brief shouldn't be a lot of quotations. Use quotations if they're, if it's really strong language. But otherwise, try to paraphrase and put it in your own words. It just makes the brief read a lot easier.
Mind you that creating a chart of cases doesn't mean that you don't need to read all of the cases, because, that's one of the first things you'll be doing, is reading through all of these lengthy opinions, because you need to know what the rationale was for whatever court, whether it's Supreme Court or a circuit court or a district court or whoever it is that you're using there, what their rationale was for deciding the case, what the facts were in those cases, because you may be using language from a case to assist you in emphasizing a point in your argument, but then the facts of that case are completely off point, and the issue that they were talking about wasn't even related to what you're saying, so you're just using language that is irrelevant. So it's important to also know specifically what the case was dealing with.
Okay, so turning to the actual sections of the brief. The argument section of the brief, it's similar to what you did in legal practice. This is where, all the meat of the brief comes from. You're going to have ancillary sections, statement of the facts. Those are important. Those get graded. But this is where your argument is. This is where you convince the court. The one main difference that is a lot different from what you learned in legal practice is we look for a CRARC method. It's conclusion, rule, application, rebuttal, and then conclusion again. A little bit different than CREAC. The rule section can embody the explanation section that you did in legal practice. So you'd state the rule, cite to the case law, and then in a parenthetical, you can explain that rule that you just stated. It's a much more effective and quick, easy way to explain a case rather than saying, in U.S. versus Cox, defendant did this, and then this happened, and writing a whole paragraph explaining it. You can really just do it in one quick parenthetical sentence.
Because you have a limited amount of space to make an effective, persuasive argument. So by doing this, you sort of create a modified version of the rule and explanation so that you're combining thoughts in one place so that you can spend more time arguing why your facts either go with or against that rule. And then another difference here is the rebuttal section. Now, when you're writing this, you will have facts at your disposal that will show you what either side was arguing. But in real life, you'd have the petitioner's brief, and then you would respond to what their arguments are. Here, you're going to be basically challenging the areas that you find to be the greatest weaknesses in the arguments on either side, and there will be. There will be areas where your side is weak and their side is weak, and so when you're writing this, you're going to have to address what it is that you find to be least persuasive about theirs and attack that in that way.
Yeah, so you get to pick what side you want to write for. When the fact pattern comes out, you decide if you want to be petitioner or respondent. We take no issue how you want to split the work with your partner. There's going to be issue 1 and issue 2. We typically suggest that one person takes issue 1, one person takes issue 2. But you need to be familiar with the other side, because when you're in oral argument, you're going to be assigned a random side. You can be petitioner in one argument, and then a half hour later in the next argument you're respondent. So you need to know the good arguments on both sides. So that's where the rebuttal section really comes in. You do need to know what the other side is going to be arguing in their brief. And that will help you for oral argument and get prepared for oral argument as well. We pretty much went through a lot of this. It's in the packet as well.
It's one thing that's important, and we're coming to it now, is emphasizing your conclusion. When you're writing to a court, in moot court, or anywhere else, you need to direct the court to where you want the argument to go. So, simply starting with whatever point it is you're trying to make, and then ending with that same point, and even mixing in the point. Again, it's not redundant. It's simply you're trying to be persuasive and hammering home that this is what you want the court to decide. So that's why we suggest you start with a conclusion, you end with a conclusion, and just keep mentioning what it is that you're asking the court to do here.
For the recording, it might be a good idea for you to wear one of these. You might as well.
So the rules section. Like I said before, you're going to state your rule. You want to cite all of the relevant statutes that support that rule. If you come up with some kind of rule that really supports your argument, but you don't have any legal case law behind it, you can't use it. I mean, you have to really have support for what you're stating in your rule. And we're making sure, as editors, it's part of our job to make sure that the fact pattern is written so that you will have a good argument on whatever side you choose.
And there are always, ways to go into public policy and finding some argument that maybe a court didn't address, but typically that's not going to be your main argument. There's going to be some sort of, legal precedent for your case. And if you are arguing something novel, then, find something that supports your position there.
I mean, there's going to be things that everybody will have in their brief. There's going to be a lot of the cases cited in the fact pattern from the Supreme Court that you have to deal with. But this is your chance to go in and find cases from lower courts with similar facts. And you really need to look at the facts in the fact pattern and the facts of the cases from other courts, from the Supreme Court opinion, circuit courts, district courts, and use those facts to help shape your rule to get the court to rule in your favor.
And on that same line of thinking here, that you should, if you're going to use a lower court, make sure that the point that the court makes in their decision doesn't conflict with a higher court's opinion, because the order of authority is that the Supreme Court has decided something. So if a lower court is going against that in some way, there needs to be at least some sort of factual distinction if for you to use that as your precedent for the rule you're making.
And for string cites, you're probably going to have some string cites in the rule statement. String cites, there's a weight of authority. I think it's Blue Book Rule 1.4. You're obviously going to cite to the Supreme Court, then circuit courts, district courts. But if you have cases from the same court, it goes in reverse chronological order, which means the most recent cases go first, and the most distant cases from the past go last, in the same line of courts, level of court. The application section is the meat of the argument section. This is where you apply your rule and you make or break your argument, really.
Yeah, this is where you'll be going back and forth and saying that your case is not like this case, or it's similar to this case because of X reason, whether the facts are similar or just the holding of the court is what you want in your case.
You want to analogize and distinguish from the cases that you've cited. Again, the rebuttal, it bolsters your credibility by acknowledging that, hey, the other side has this good argument, but our argument's better because whatever reason. The rebuttal section doesn't need to be every argument the other side is going to make, pick the strongest argument and rebut that.
Yeah, because when, I know we're here to talk about brief writing, but when it comes down to doing your oral arguments, you're going to be up there, trying to deflect arguments that the other side's making. And so you're going to need to know, like we said earlier, what the other side is going to say, because that's what you're going to be up there arguing. And so to address that in your brief, gives the person reading it, the impression that you know why the other side's wrong and why you're right.
So the last conclusion, it's going to be a lot similar to the first conclusion, but just narrower. You can state whatever your first conclusion is, but in a more concise language.
And this is not like the conclusion that you would put at like the end of the brief saying that, we asked this court for relief. It would be more of a, we, would like this, to hold that this is the proper rule, proper analysis of this case, and this is why you should hold in this manner. Right.
It's different than the ancillary conclusion section, which there is an example of that in the handout, which is just going to be one sentence. And you're going to say, for the foregoing reasons, we ask this court to reverse or affirm the circuit court's opinion. It's a quick one sentence. You don't have to go into reasoning there. This conclusion is the conclusion for the application and the argument section, and this is where you state your reasoning for the conclusion.
And we're going to go into the structure of the argument, but this applies to every point and subpoint and section that you do, because basically each of those is a mini argument, and you're going to use this format to get to the conclusion in each of these sections. So whether you have an umbrella section, then point, subpoints, and each time you do that, you're going to have to come to a conclusion about that.
Right. You want to have CRARC overall. You want to have it for the entire argument section, and then in each subpoint, you need to have CRARC. Each subpoint, you need to have CRARC. So you want to just make sure that you're doing that in every section.
Okay, so here we are. Your argument section may, it depends on how the issues are set up, have multi-pronged areas where you need to address certain issues, but you don't want to do it all in one section, because it would just be too complicated or too confusing for someone reading it to understand what your argument is. So just as an outlining, you would probably break it down into points and subpoints, which would address each of the sections of the issue that you are doing in a logical order. Taking an example from last year, there was a test that had to be applied, and so it had two prongs. So you would break down the issue into two subpoints that was each part of the test. Now, just because you might be arguing that the facts of your case might dictate that you don't need to go beyond the first prong of a test, doesn't mean you don't need to address the second part of the test. It always is helpful essential to go into all the areas of the law that are covered in a legal test or any sort of rule. So that you can say, assuming arguendo, so you're just accepting as true that this is, even if you're arguing against it, just so that if a court decides that they don't agree with your position, you can say, okay, fine, moving on, even this part doesn't apply or does apply. So it's important to go through the motions. Actually, one more thing on that. Also, don't break it down into too many points, subpoints, because at some point your argument loses its force if you don't combine them together to give your overarching conclusion. So break it down to the I guess the least.
There's no right or wrong way to really do it, but there are better ways and worse ways. There's most likely going to be two main point headings for issue 1 and issue 2. And then depending on how the issue unfolds and how you think is the most clearest way to express your argument, you're going to have maybe 2 or 3 subpoints, and under 1 or 2 of those you might have 1 or 2 subpoints. But don't go crazy.
Right.
Don't have 5 or 6 subs under each subpoint, and then you have way too much going on. Because you do need to stay within a page limit. The argument section page limit, I believe, is going to be about 22 pages, and overall it's going to be a 30-page page limit, including the ancillary sections. So this is what we're talking about with the point headings. This would be, for example, issue 1, subpoint heading, and then the sub-subpoints. The formatting for these, there's no right or wrong way to do it. We recommend that the point heading is in all caps and bold. The subpoint is bolded with every first letter of every word capitalized. And then the sub-subpoints, you would just capitalize the first word, the first letter of the first word, and then underline the rest. There should be periods at the end of the point headings, subpoints, and sub-subs. But if you want to do it another way, as long as it's consistent throughout the brief, that's fine.
So here we have an example of a main umbrella point heading and then a subpoint and sub-subpoints below that. This was taken from a brief from last year's competition, and this was about student speech, free speech argument in public school. As you can see here, there was a two-prong test that was being applied. It had to do with this case, Tinker versus Des Moines. And so the first subpoint dealt with one half of it, and the second subpoint dealt with the other part of the test. And so this is how you would typically break down a issue that involved a multi-pronged argument.
And you have an example of one of these in the packet as well. So if you want to take a look at it, it'll help you with the structure of the point headings. So quoting case law, like I said before, you don't want to do it that often, only if the language is really strong. Paraphrasing is a lot more effective.
To that end, if you do choose to paraphrase a case, make sure it is your own words. And if you do attribute language from a case without citing to it, that's plagiarism of the case itself. So make sure that if you don't use direct quotes, that what you do use, you do give credit to the case itself and where it came from. And if it's the exact language, then you need to use a quote.
Yeah, and you don't want to state what the fact pattern says. Maybe the way that the district court or circuit court in the fact pattern described the case is really good, and you want to use that. You can't. That is plagiarism. You need to figure it out on your own and come up with your own words to describe the case. You just can't take whatever the court said and put it in your brief.
Unless you're directly quoting them for a particular assertion that you're trying to reach.
Right, unless you're citing to the district or circuit court opinions. And there will be citations recommended or given for the district court and the circuit court opinions so that you can cite to them respectively.
We're a big fan of parentheticals because in this way you're not going to, you're not elaborating too much on the facts of the case. You're just boiling it down to what the essential facts are that you're using to bolster your argument. So in using a parenthetical regarding a case, you're just saying, why is this case on point for what I just said is the most persuasive argument here? So in this case, we have a couple circuit court opinions that have parentheticals, which just describe the factual situation there that is most on point for the assertion that comes at the beginning of the argument.
Yeah, you might want to include an important fact. Usually parentheticals will begin with holding or stating. That's a good way to begin a parenthetical. You don't have to. You can quote in a parenthetical, but we don't recommend doing it frequently. Try to stick to explaining the case in as few words as possible, but still getting in important facts and important support for whatever you just stated above and cited to. Okay, so the questions presented, there's pretty much two different ways you can formulate a question presented. And I'm going to turn to the section in the handout. I don't know.
Okay, maybe it's not. Just in the PowerPoint?
Well, we have examples here. I can't find it on the handout. It's definitely in here. You want to look for it? The first way would be to state like this. Under Tinker, can the First Amendment right to freedom of speech be limited by a public school when the speech is made by a student on the internet and the speech is likely to come to the attention of students and school administrators? Notice that there's a question mark there. This format follows under, can, and when. I tried to highlight them. I don't know if it's if the bold is showing up, but if you just Google questions presented, Georgetown Law School has a really good PDF. It's a couple pages long that explains how to write a good questions presented, and they recommend this format using under, can, and then when, and stating some facts, relevant facts to the question.
Yeah, because when you read the fact pattern, there's going to be at the end, the issues on cert, which is what the court has asked to bring up for their consideration. It's typically not advised to just simply copy and paste the issue on cert and say this is the question presented.
Yeah, you can't do that.
Because what you're trying to do here is phrase the question in a way that supports your argument, the argument you're going to make inside the brief. So you might want to change the phrasing so that it doesn't, would persuade someone reading it to say, oh, okay, this is what they're going to be going after, and this is what they want us to find.
The question presented needs to be framed with your argument in mind. So state facts that support your conclusion. Don't just copy and paste whatever the question is. Or
those will be very neutral, whereas yours is supposed to be the most persuasive on your side of the argument.
It's the first opportunity for you to really start to get your argument across. The questions presented is the first section that comes across on the brief. So you want to make sure that your argument is starting to form at this stage of the brief. The next example uses whether. And if you're going to use whether, just don't use a question mark. It's not appropriate. So this format follows the whether, under, and when structure. So whether the First Amendment allows public schools to regulate online student speech under Tinker when the speech is likely to come to the attention of students and school administrators. Notice the whether, under, and when.
You can see here, this is a little more neutral way of presenting it. This might be useful when the area of law is a bit undecided, or if where you're finding is unsettled at the circuit court level or whatever it is that you're looking at. You might find it better to look at a question presented this way because it's not something that has been decided at the Supreme Court level, if that's what you are looking at.
The cover page is the only section of the brief that needs to follow the Supreme Court rules. It's Rule 34 if you want to take a look at it. This is a copy of it. You can just Google Supreme Court rules and get a PDF of the rules. An example of a cover page is here. This is actually Garrett's brief from last year. They won best petitioner brief. You don't need to have the Old English font for in the Supreme Court of the United States. If you Google briefs to the Supreme Court and look at pictures of the briefs, they have that font. And you can get it on a PC. I think on a Mac it's
download the font.
You have to download it. So. If you want to do it, I mean, that's great, but you don't need to. You can just use Times New Roman. Just going back to that, don't put any identifying information on the brief. You get a team number, right. That's what goes on the brief.
That is very clear. You'll see in the rules, if you identify yourself or your partner, that's the disqualification of your brief, because this is all being done anonymously. The graders won't know who you are. This is to ensure the fairness of the whole process so that we don't know who it is that's submitting these briefs.
The summary of the argument is a brief statement of the entire argument. I like to write it after I'm done writing my argument section because I don't really know what my argument is ultimately going to be until I'm done writing it. It's one of the last sections that I write when I put together a brief, and it doesn't need to be long. You don't need to cite to any authority. You just need to state what you're going to say in the argument section. try to write it so that somebody who doesn't have the time to sit there and read all 22 pages can get the gist of what you're going to say.
And it can even so much as follow the point headings that you use in your argument so that you can go step by step as to what the brief is going to argue, but then just use some support and facts that you find most relevant and include that in the summary.
I know this says no more than 2 pages, but even 2 full pages is probably a little bit too much. If you can stick to a page and a quarter, page and a half, it's probably a good length. You want to do the...
Yeah, so the procedural history is exactly how the case got up to the Supreme Court. So it would include the citations to the lower court's decisions. It can even include, it won't include facts, but it can include what the lower courts held and just show that, how this case came to be where it is while you're reading it.
You need to have an opinions below section. That's something you probably didn't do in legal practice. Opinions below is 2 sentences. The example down here, the opinion of the 13th Circuit is reported at, you put the cite, and then the opinion of the district court is reported at, and you put the cite. It should be in that order. That needs to be in the brief. It is in briefs that are submitted to the Supreme Court. That's why we have you do it. So some blue booking tips.
This cannot be understated. Yeah, blue booking, you'll become your friend. You'll need to know how proper citations, spacing, abbreviations, rules. These are things that you'll be consulting constantly when you're writing this brief.
Yeah, I mean, I didn't really realize it my 1L year, but writing this brief, I started to get in the habit of turning the blue book around, and you just have that table there that is a quick reference. It'll give you the rule, and you go from there. You'll definitely become much more familiar with the blue book through writing this brief. General advice is to be consistent. If you're going to underline cases, underline all the way through. If you're going to italicize the citation, the case names, then italicize all the way through.
And I think the first point on here about consistency is also important. You will be working with a partner, and hopefully that relationship will sustain itself throughout the brief writing process. And in doing so, you'll have to consult each other's writing to make sure that there's not, any overlap between what the issues that you're both doing, and also that the style looks fairly consistent throughout. So if one person decides to use parentheticals, the other person cites facts in the body of the, it's recognizable throughout. So consistency in working with your partner to make sure it is consistent in style and format is important.
There's a lot of little things, like the cover page shouldn't have a number on it, but then the questions presented and the ancillary sections have Roman numerals, and then it switches over to the argument section, which has regular numbers. The way to do that, it's kind of hard to figure out in Word, but if you go to insert break and then section break, and then you put the numbering in and you click don't continue from next section, if you can follow what I'm saying, then you can actually separate out and have Roman numeral 1, 2, 3, and then the next section is regular number 1, 2, 3.
Actually, if the blue book is going to be your best friend, Microsoft Word or whatever you choose to use will probably be your worst enemy, because you'll be finding that a lot of times the formatting is very difficult. But the end product and the way it looks at the end is important, that so the person reading it can follow through your entire brief from start to finish and really get a sense of what your argument is and not be distracted by strange formatting or inconsistency between the 2 issues that you write.
The questions presented, table of contents, and table of authorities appear on their own separate pages. So you don't want to start the table of contents or the table of authorities halfway through a page, bump it down to the next page, and start it there. The rest of the brief can flow on the same page, have different sections on the same page. But those 3 sections in the beginning should be independent.
We've already gone over the submission.
So some grammar tips about active and passive voice. Although in some cases passive voice is appropriate or is correct, you should really be striving to write in all active voice. Something for me is I tend to put in commas where they don't belong when I'm reading, and then go back and edit. So just be careful of where you're inserting commas. Do they really belong there?
Especially in a series when you're describing different elements, there is a comma between the and the last element of the series, or the or,
right.
Just to separate.
If you're going to use an Oxford comma, then do it consistently
Yes.
throughout the brief. An Oxford comma is the comma before the end in a string of...
Yeah, before the conjunction.
Yeah.
And as far as active and passive voice goes, something being done to the object or the subject of the sentence, what was it? The dog was barking at the mailman. Actually, that makes sense, doesn't it? I'm something done to the. I'm drawing a blank on an example. The editors are here. What? The book was being read by me. Yes. There we go. That is a much better example than one I gave. So there, you have. I read the book. It would be the correct way of forming
The active voice.
And the active voice.
Yeah. Other than that, we don't have too much else unless you guys have some questions. There's a lot in this packet. I definitely suggest reading it in full when you get home. Any questions? Okay. Good luck, guys.
Can I just add one thing that I just
Sure.
remembered from last year? I just want to say thank you so much. That was a really great review. Thank you. And if you guys remember all this stuff, that'll be really amazing and great. I just wanted to add something from past years that I want to make sure is absolutely clear. Michael and Garrett talked about plagiarism, how if you take language from the fictional district court and circuit court opinions that are going to be in the fact pattern, you have to treat them the way you would treat real opinions. So you need to paraphrase that language as they said, or put it in quotes and cite to it. Otherwise, it's plagiarism, even though they're not real opinions. They're fictional opinions that our fact pattern authors are writing and giving to you as opinions. You still need to quote it or paraphrase it. But I wanted to add to that, that when you're writing your statement of facts, the same rules apply. Even though it's not law or legal analysis, you can't just lift the facts out of the fictional fact pattern you're given and put it in your brief without either paraphrasing it or quoting it and saying where you got it from. So that's plagiarism. And last year, I'm guessing that, people were in a rush and they weren't quite finished and they just lifted sections of the fact pattern into their brief. And we were concerned that maybe it wasn't clear to people that that's plagiarism, but it's plagiarism. Anytime you take language from any other source, even if it's not legal analysis, you need to make it your own language or you need to quote it, period. Because if there's plagiarism and there's a question about it, it's bad news for everybody and nobody wants to get involved with that and it will get caught. So even if your intention is just because it's facts and you don't, there's no other way to say it and you're not thinking it's plagiarism. I just wanted to make sure that we're absolutely clear about that so nobody has any confusion about that. And then I just wanted to add also with rebuttal, I think CWORK is really helpful as a way of writing a brief. It's in the real world, people don't always follow any formula at all, believe it or not. When you write a brief, these are all just helpful ways to get started. For Moot Court, it's important to learn in this way, partially because it's the best way to understand your arguments is to really understand the arguments against you. And so that rebuttal section that Moot Court uses is not just for you to give any old argument from the other side or kind of a weak argument from the other side that you can shut down, that you can rebut again and win. It's to actually deal with the best argument for the other side. So use that rebuttal section not just to come up with any old argument the other side might say, but the strongest argument that is really going to be the biggest, hardest thing that you're going to have to deal with when you're on your side. Because in Moot Court, as they said, you stand over here and argue for the plaintiff or the appellant 1 minute, and the next minute you're on the other side. So if you didn't actually think about the best argument for the other side, you're not going to be in a great position to turn around. And you're going to have to rebut both sides, and you're going to have to rebut the best, most persuasive arguments for both sides, not just any old argument. And then finally, I just wanted to put in a shameless plug for Advanced Appellate Advocacy, which is a course that's being offered in the fall. If you're interested in appellate work at all, it's a really great class. We learn fine points of brief writing. We learn a lot about appellate practice, and we have a case where we do a simulated, where you have a client and you do an oral argument, and we get outside judges come in, and you get feedback. And we're also going to visit outside courts, appellate courts, and we're going to have a repeat performance. It's just pretty brand new news of the Second Circuit coming to New York Law School again this fall to sit and hear cases, and both Moot Court and my Advanced Appellate Advocacy class works with that day. We're going to read some of the briefs from those cases ahead of time and get involved, and then come and watch the lawyers do the arguments and really learn about how lawyers can be the best advocates they can be by both doing oral arguments and looking at the written briefs in those cases. And then there's going to be, you know, an opportunity, hopefully, to speak to the justices who sat and heard those arguments and read the briefs. So it's really exciting. So I know most of you have already set your schedules for the fall, but if you have any movement in your schedule and you're interested in appellate advocacy, Advanced Appellate Advocacy is a great class, and I'd love to have you. Okay, back to the program.
Thank you, Professor. Okay, guys, so I know we gave you a lot of information today, and the most important thing to remember is that this information essentially is to help you get through the process and to sort of schedule yourself during the summer. So don't get overwhelmed. You guys are all more than capable of doing this, and we really hope to see you guys at the next Moot Camp, where Catherine and I will be talking about the oral argument process itself and how to become better oral advocates. Right now, Catherine is going to talk to you guys a little bit about, or she's going to clarify the rule for submission. Mike sort of touched upon that before. I don't think it was very clear, though, so we want to make sure that that the rule is clear and that you guys know what you have to do when you need to submit the brief, okay? So
as Ariel said, I know that it may have been a little overwhelming hearing all of the blue booking and all the little specifics that go into the brief writing, but I promise you that it will not only help your brief score, but it will also help your score in the second portion of the competition, which is the oral arguments. In order to successfully deliver an oral argument, you have to be very familiar with your facts. You have to know how to play with the facts. You have to know which are in your favor, which aren't in your favor, and you really need to know the fact pattern. So when you're writing the brief, really pay attention as you're reading through the fact pattern and take notes. I know last year I made a list of unfavorable and favorable facts, and I used it throughout the entire competition, both when writing the brief and when going through the oral argument stages. So I promise you that it's not only about writing a great brief, but it's going to help the second portion of the competition. And once you're familiar with the facts, it kind of takes all of the nerves away, I feel. So that's just a personal pointer that I have for you, that it may be a great idea when you get the fact pattern just to kind of rip it apart and look at, you know, the favorable and unfavorable sides. Also, as Garrett said, this is an open universe, but there are cases cited in the fact pattern that may be able to lead you in the right direction. So it's always a great idea to read through those first before you start writing. Now on to the submission part. Basically, we will, as Mike had alluded to, we will be posting the official rules of the 2013 Froessel competition. However, just to make clear, what we require is that you electronically submit the brief as of August 11th, which is a Sunday, by 9:00 p.m. It must be electronically submitted to the Froessel Moot email address, which will be clear in the rules. You'll have the email address. It must be submitted electronically by 9:00 p.m. There are no exceptions for that. If it's not submitted electronically, you will be disqualified from the competition. With that being said, we also require the 4 printed submissions to be delivered to the Moot Court office by 9:00 on August 11th by 9 p.m. The clock in the Moot Court office will keep the time, so we'll be waiting for you and we'll be there to collect the briefs. In the event that you cannot deliver the paper copies, we would need a showing of good cause, some reason why you couldn't make it. We know that things happen. We don't want to disqualify people that worked very, very hard. So that is sort of our way to be understanding and to know that things happen. But, we would really appreciate it if you can let us know beforehand that you will not be coming to deliver the paper copy and why. These paper copies are important. We have graders that really look at these briefs and grade them accordingly, and we have a number of people working on them at one time. So we really do require the paper copy. However, if you absolutely cannot make it because of some traumatic event or unfortunate incident, just let us know. And as long as the electronic copy has been submitted by 9:00 p.m. on the deadline, then you'll be okay. And this will all be very clear in the rules, but I just wanted to emphasize, we really don't want people working really hard and then, for lack of a better word, blowing it. So, really just try and conform to the rules. And as far as the brief writing portion, does anyone have any questions right now that off the top of your head? Anything that was unclear? Or you
Sorry,
can clarify?
did someone have a question over here before, or did you have a question?
We're trying to figure out dates, sorry.
Oh, okay, all right.
I apologize.
That's no problem. Anyone else, or?
Want to say something?
Just wanted to say that there are awards given for best brief. Catherine and Garrett won one last year, so there is something to writing a good brief. There's a best petitioner and best respondent, so definitely put your best work into it. I think there's also best oralist given as well. So
And finalists, too.
yeah, it's something good to put on the resume, and I think you get a little plaque. So good luck, guys.
Thank you.
All right.
And
Thanks,
also, sorry, you also get a best group award or best team award, I should say. So that's also something to look forward to, and something to put on the resume, guys. I mean, it's great to be able to put best petitioner brief, best respondent brief on your resume. Also, just about Moot Court 2, which Moot Camp 2, which will be July, is it 14th?
I believe so.
July 14th. Just check the website, I'm pretty sure. And what we'll do during that portion is actually host a mock oral argument in front of you by some of our team members. We'll get something together so you can kind of see what to expect during the second portion of the oral argument stage. And as Professor Abraham alluded to, that's the fun part, guys. Once you write this brief, you're going to be so excited to get up and talk to the judges and really just show what you can do. And it is a little bit nerve-wracking, so we want you to come to Moot Camp 2 if you can make it, just so you can see it happen before your eyes and kind of see what to expect on the second portion. And if you have any questions, please feel free to reach out to Ariel and I. We're here for you. We know that this isn't easy. We know that it's the summer, but we really hope that you put a good faith effort in, and we're very excited to see what you can do. Thank you very much for coming.
Thank you, guys.
Okay, this will also be in the rules, but for partnering up, you can choose a partner, which I'm sure you guys know you've registered, if you've registered for the competition. If you have not registered for the competition, please do so as soon as possible. The link is on the Froessel Moot Court website, so please register. Upon registration, you will indicate if you have a partner in mind. If you don't, you will be paired with a partner. Moot Court will make sure that you're paired with someone. And in the event that you end up having one partner or writing the brief on your own, the only reason why you should be writing the brief on your own is if Moot Court cannot provide a partner to you or it's too late in the process to actually pair you up. In the event that your partner, for some reason, drops out of the competition and doesn't make it to the oral argument phase, that's okay. It won't affect you. But they should let you know, and you should alert us to that fact. And you're not affected by what your partner does in the oral argument stages. So I just wanted to make that clear. This will all be in the rules. But if you have any questions about it, feel free to reach out to us. Okay? Thank you.